People like you always think you understand the law." The words landed in the courtroom the way a slap lands on skin, sharp, public, and designed to leave a mark. They came from the bench, from a man in a black robe who leaned forward with both hands flat on polished wood, his chin tilted at the angle of someone accustomed to speaking down. The gallery of Courtroom 3 in the Henrico County Circuit Court went still. Not shocked still, practiced still. The silence of people who had heard variations of this sentence before, aimed at other faces, other names, other bodies that didn't look like they belonged in the room. The woman at the petitioner's podium did not flinch. She stood 5'6" in a navy blazer that had been pressed but not recently, flat shoes, no jewelry, except a watch with a cracked face. Her hands rested on a leather satchel, so worn the stitching had gone white at the corners. She held a pen, not expensive, the kind bought in packs of 12, and a legal pad already half full of notes in handwriting too small and too even to read from a distance. The judge had just finished his sentence. 22 years on this bench had taught him that sentences like this one produced results. The pro se litigants, the ones who came in without lawyers, clutching printouts from legal websites, stumbling over words like whereas and hereinafter, they usually crumbled here. Some went quiet. Some raised their voices and gave him grounds for contempt. Some packed their folders and left, which was fastest of all. This woman did none of those things. She picked up her pen. She wrote something in her notebook, slowly, deliberately, the way a person copies a license plate number at the scene of an accident. Then she looked up. "Your Honor, could you please repeat that for the record?" Her voice carried no anger, no tremor, just a request, neutral as a glass of water. The court reporter's fingers paused over the keys. The opposing attorney at the defense table, a man in a suit that cost more than the woman's entire outfit, exchanged a glance with the clerk. The judge's expression tightened by a fraction. He had told her what she was. She had asked him to say it again. The man who said those words from behind the seal of the Commonwealth of Virginia did not know that the woman standing at his podium had been sent to his courtroom specifically to hear him say them. He did not know that every syllable he had spoken since 9:47 a.m. was being recorded by a device no larger than a button, tucked inside the lining of that worn leather satchel. He did not know that she had already filled 73 pages of notes across 4 courtrooms in 2 states, that she had been doing this for 11 years, and that the last 3 judges whose courtrooms she had entered were no longer sitting on any bench. He thought she was a tenant fighting an eviction. He was right about that, technically. But the eviction case was the door, and what she had come for was behind it. She closed the notebook, and for the first time since the hearing began, allowed herself the faintest trace of a smile, the kind no one in that courtroom understood yet. If you think she's going to let that slide, hit subscribe, because what she does next changes everything. 3 weeks earlier, Angela Mercer checked into a Residence Inn off West Broad Street in the Richmond metro area with 1 suitcase, a garment bag, and the leather satchel she had carried through courthouses in 9 states over the past decade. The room was a standard extended stay. Kitchenette, queen bed, a desk too small for real work, but adequate for someone accustomed to making do. She unpacked methodically. 4 blazers, all dark, all unremarkable. 3 pairs of flat shoes. Underwear and basics for 3 weeks. A laptop that went immediately into the room safe, and a thick manila folder that she laid on the desk, like a surgeon laying out instruments. She did not open the folder that night. Instead, she drove the rental car, a gray Nissan Sentra, the most forgettable vehicle on any lot, along the route she had mapped online. The Henrico County Courthouse sat on East Parham Road, a brick and glass building that could have been a large dental practice from the outside. She circled the parking lot once, noted the entrances, noted the security setup visible through the glass doors, noted the position of the handicapped spots nearest the main entrance. Then she drove back to the hotel, ate a sandwich from the gas station next door, and went to bed at 9:30 p.m. with her phone alarm set for 5:45 a.m. The next morning, she arrived at the courthouse at 8:15, 30 minutes before the clerk's office opened. She stood in the hallway with the early crowd, a mix of people waiting for traffic court, a woman with a stroller and a stack of forms, 2 men in suits who walked past everyone without making eye contact. Angela held the posture of someone who expected to wait. hands folded over the satchel, eyes forward, patient in the particular way that black women in government buildings learn to be patient, not because patience comes naturally, but because impatience is a weapon others will use against you. The information desk opened at 8:45. A woman in her 60s sat behind it, bifocals on a chain, the weary expression of a person who had answered the same 12 questions 10,000 times. "I need to file a civil petition in circuit court." Angela kept her voice even, unremarkable. The woman glanced up, looked at Angela's blazer, her flat shoes, the satchel. Something in her expression recalibrated. "Family court is downstairs, honey." The word honey did not land as a term of endearment. It landed as a sorting mechanism, a quick assessment that placed Angela into a category before she had finished her sentence. "I'm filing a civil housing petition, circuit court." Angela held up the filing. "Can you direct me to the clerk's window?" The woman pointed toward the elevator bank without further comment. Angela nodded, thanked her, and walked to the second floor. She did not write anything down. Not yet. The information desk was not part of the record, but she filed the interaction in the place where she stored such things, a mental ledger that had, over 11 years, become as precise and organized as any case file. The circuit court clerk's office occupied the east end of the second floor. Behind a glass window that slid open like a bank teller's sat Piper Stokes, whose nameplate read Clerk of Court in brass letters that had been polished more recently than anything else in the room. Piper was mid-40s, blonde hair pulled into a twist that might have been stylish 10 years ago, reading glasses perched on her nose. She had the posture of a woman who controlled a small kingdom and knew it. Angela slid the civil petition through the window. Piper took it without greeting, without eye contact. She flipped through the pages with the mechanical attention of someone looking for a reason to say no. She found one. "Can't accept this." Piper set the filing down. "Margins don't meet local rule specifications, half-inch minimum on all sides." "Which specific rule requires half-inch margins?" Piper waved toward a thick binder on the counter, the Henrico County Local Rules of Practice, bound in faded blue vinyl. "It's in there. You'll need to reformat and refile." She slid the window halfway shut. Not closed, halfway. The universal bureaucratic signal for, "This conversation is over, but I'm not technically refusing to help you." Angela pulled the binder toward her. She did not flip randomly. She went to the table of contents, ran her finger down the page, turned to the section on filing requirements. She read for approximately 90 seconds, her finger tracking line by line. The margin requirement Piper had cited did not exist. The local rules referenced Virginia Supreme Court formatting standards, which required 1-inch margins, the exact measurement Angela's petition already used. She did not announce this discovery. She did not tap on the glass. Instead, she did something that, to anyone watching, would have seemed unremarkable. She took a photograph of the relevant page with her phone, pulled a small index card from the satchel's front pocket, wrote the date, time, and a brief notation, and slid the card into the satchel beside the phone. Then she left. The next morning, she returned at 8:15 with the identical petition. Same margins, same formatting, not a single word changed, and filed it through the same window. Piper accepted it without comment, stamped it, and assigned it a case number. C. L. Gotch, Noi Hai, Kong Hai Num Gach Noi, Khom Bon Bon Mot Bay. She did not acknowledge that she had rejected an identical document 24 hours earlier. Angela did not remind her. The satchel was already 2 index cards heavier. That afternoon, Angela sat in the gallery of courtroom 3 for the first time, not as a petitioner, but as a public observer. Court proceedings in Virginia are open to the public under the state constitution, and Angela exercised that right by finding a seat in the second-to-last row, satchel on her lap, notebook open. She watched 3 cases. In the first, a Latino man in a janitorial uniform tried to explain that his landlord had changed the locks while he was at work. He spoke carefully, his English accented but clear. Judge Lowell Meade, who presided from the bench with the comfort of a man sitting in his living room, interrupted him at the 42nd word. "Speak up, And if you need a translator, get one before you come back. This isn't a language class. The man's attorney, court appointed, visibly overworked, said nothing. The gallery said nothing. The court reporter typed, though Angela noticed that his fingers paused during the judge's comment, resumed only when the attorney began speaking again. In the second case, a young black woman waited for her name to be called. She stood when the bailiff announced her case number. The bailiff, a thick-bodied deputy named Gage Lindell, according to the name stitched above his breast pocket, positioned himself behind her as she walked to the podium. Not beside her, behind her, close enough that his belt buckle nearly touched her back. His hand rested on his belt, not on his weapon, but the proximity communicated what a weapon would have communicated more bluntly. The woman's shoulders tightened. Her voice, when she spoke, was barely audible. In the third case, a property dispute, Angela observed the court reporter more carefully. His nameplate read, Nolan Voss. He typed steadily through the attorney's arguments but paused, fingers lifting a quarter-inch off the keys, during two separate exchanges where the judge made comments from the bench. Both comments were dismissive. Both were directed at the plaintiff, who was black. The keys resumed when the defendant's attorney spoke. Angela wrote nothing visible during these proceedings. She sat with her notebook open but her pen still, the way a person sits in a theater, watching, absorbing, appearing passive. Only her eyes moved, tracking the relationships in the room. Meade to Piper, Piper to Voss, Voss to Lindell, Lindell to the litigants. A system with a hierarchy, a rhythm, and an understood set of rules that existed nowhere in any written code. That evening, in the hotel room, she sat on the bed with the manila folder open in front of her. Inside, 47 complaint letters, photocopied, names redacted with black marker. She had read them all before arriving in Henrico County, had in fact been given them as part of her briefing. But she read them again now, in the context of what she had seen. The first was dated Haingin Kongtrum Moimot. A woman whose name was blacked out described being told by the judge that her divorce petition was wasting the court's resources on matters that should be handled at home. The second, from Haingin Kongtrum Muibon, described a custody hearing in which the judge awarded sole custody to the father without hearing testimony from the mother, a black woman who had arrived with documentation of domestic violence that was never entered into the record. The third, from Haingin Kongtrum Mui Sao. The fifth, the ninth, the 23rd, 47 letters, 14 years. Everyone dismissed. Angela closed the folder, picked up her phone, scrolled to a contact labeled only RH. No name, no photo, no additional information. She held her thumb over the call button for 3 seconds. Then she set the phone down without dialing. Not yet. She had work to do first. The hearing for case number C. L. Gachnoi Hai Hong Hai Num Get Noi, Hong Bon Bon Mot Bay, Mercer v. Commonwealth Property Holdings, LLC, was scheduled for March 3rd at 9:30 a.m. The case was straightforward on its surface, an unlawful eviction claim. Angela alleged that Commonwealth Property Holdings had changed the locks on a rental unit without providing the required written notice under Virginia Code Section 55.1-1245. The claim was real. The unit was real. A modest apartment in the Church Hill neighborhood that Angela had leased 3 months earlier under her own name. The eviction had been orchestrated with the property company's cooperation, though no one at Commonwealth Property Holdings knew why a government investigator wanted to be illegally evicted. They knew only that they had received a letter on official letterhead requesting their participation in a matter of state interest, and that compliance was strongly encouraged. The hearing would give Angela what she needed: repeated, documented access to Judge Lowell Meade's courtroom as a named party with standing. She arrived at 8:45, passed through security without incident, this time, and took her seat at the petitioner's table. The satchel went on the table beside her, positioned so the small recording device in its lining faced the bench. She opened her legal pad to a fresh page, wrote the date, wrote the case number, waited. Win Calloway arrived at 9:22, 8 minutes before the hearing. He was the kind of attorney who entered rooms the way Cologne enters an elevator, ahead of himself, filling space before anyone could object. Gray suit, burgundy tie, leather briefcase that probably held $200 worth of contents and cost 6 times that. He set the briefcase on the defense table with the casual authority of a man who had won cases in this room before and expected to win this one. He glanced at Angela. Registered, black woman, no attorney, modest clothing. His assessment was instant and visible. A slight relaxation of his shoulders, the micro-expression of a poker player who has seen his opponent's cards. Miss Mercer? He extended a hand across the aisle between the tables. Wynne Calloway. I represent Commonwealth Property Holdings. Angela shook his hand, firm, brief. I reviewed your filing. His tone carried the particular warmth of a man who is about to be unkind. I think we can resolve this quickly. I appreciate that, Mr. Calloway. Angela's voice gave nothing. I believe the evidence supports my position. He smiled, the kind of smile that substitutes for a reply, and turned to arrange his papers. At 9:31, the bailiff called the courtroom to order. Judge Lowell Meade entered from the side door, robes flowing with the practiced sweep of 22 years of identical entrances. He settled into his chair, adjusted his glasses, scanned the room. His eyes passed over Angela without pausing. Another pro se litigant. Another Tuesday. Case number C.L. Gach Noi Hai, Kong Hai Num Get Noi, Hong Bon Bon Mot Bay, the clerk announced. Mercer versus Commonwealth Property Holdings. Calloway stood first, buttoning his jacket. Your Honor, before we proceed, the defense moves to dismiss under Virginia Code Section 8.01-271.1. The complaint lacks the specificity required for a housing claim. The petitioner has failed to identify the precise statutory provision allegedly violated, and the factual allegations are conclusory at best. The motion was standard, a procedural gate designed to end cases before they began, particularly effective against unrepresented parties who didn't know they could push through it. Meade nodded, already inclining toward agreement. Ms. Mercer, response? Angela stood. She did not look at Calloway. She looked at the judge. Your Honor, Section 8.01-271.1 requires that every pleading be signed and state the facts constituting the claim. My filing contains 14 specific factual allegations across 3 pages, including dates, addresses, and the specific statutory provision. Virginia Code Section 55.1-1245, the landlord's obligation to provide written notice before lockout. I have a copy for the court if needed. She had not read from notes. She had not stumbled. She had cited the statute as if reading it off the posted sign on the courtroom wall, which, in fact, listed the filing requirements in paragraph 4 of the Information for Pro Se Litigants notice tacked beside the door. Meade's pen stopped moving. For a fraction of a second, visible only to someone watching closely, which Angela was, his eyebrows lifted. Then the mask resettled. Anyone can read a sign, Ms. Mercer. The gallery produced a scattering of quiet laughter. Calloway's mouth twitched. Piper Stokes, at her station, did not look up, but the corner of her lip curled in a way that confirmed she was listening. Angela wrote in her notebook. She did not respond to the comment. She waited. Meade denied the motion to dismiss. Even he couldn't throw out a complaint that met every statutory requirement, not with the record running. But he had already signaled the room's hierarchy. He turned to the substance. Mr. Calloway, your client's position on the eviction? Calloway launched into a prepared response about lease violations, maintenance disputes, and the property company's good faith efforts to communicate with the tenant. Angela listened, pen moving steadily across her pad, noting not just the content but the pacing, how Meade let Calloway speak for 4 uninterrupted minutes while she had been cut off at 90 seconds. When Calloway finished, Meade turned to Angela. Ms. Mercer, your witness list indicates 4 individuals. This court doesn't have time to hear 4 witnesses on a housing dispute. You'll get one. Your Honor, the 4 witnesses address separate elements of the claim. Notice, lockout procedure, damages, and the property company's pattern of similar. One witness, Ms. Mercer. Meade's voice carried the flat finality of a door closing. This is my courtroom. If you want a trial with a full witness list, hire a lawyer. Angela did not argue. She picked up her pen. Your Honor, could you please state the legal basis for the witness limitation so the record reflects the court's reasoning? The request was polite, neutral, procedurally appropriate. It was also, and Angela knew this precisely, the one question Meade would not want to answer because there was no legal basis. Virginia's rules of evidence allowed parties to present witnesses relevant to their claims. The court could limit cumulative testimony under Rule Hai Chom Bon Kong Ba, but only with stated reasons. "This is my courtroom" was not a stated reason. Meade's jaw tightened. "The legal basis is that I said so. This is my courtroom. If you want to play lawyer, go to law school." He turned to Calloway. "Mr. Calloway, your client is directed to provide discovery documents by March 10th. Ms. Mercer, you have until the 17th to respond. Next hearing date, March 19th. We're adjourned." The gavel came down. Meade rose. The courtroom stirred with the shuffling of papers and the scraping of chairs. Angela remained standing at the podium for 4 additional seconds, pen still moving, finishing a notation. Then she gathered her legal pad, her satchel, and the copy of her filing that Calloway had not bothered to look at. She walked up the aisle, past the gallery, through the double doors, into the hallway. Her face betrayed nothing. The satchel hung from her shoulder, its recording device having captured every word spoken in Courtroom 3 between 9:31 and 9:58 a.m., including 2 statements by a sitting judge that would later be entered into evidence as Exhibits A1 and A2 in a proceeding that Judge Lowell Meade did not yet know existed. In the parking lot, Calloway caught up. "Little tip, Miss Mercer, Ms." He walked beside her with the ease of a man who believed he was being generous. Judge Meade doesn't appreciate people who waste his time. File a reasonable settlement offer. Save yourself the embarrassment. Your case isn't strong enough for a fight. Angela thanked him. A single nod, a murmured, "I'll consider that," and she got into her rental car. She sat for 12 seconds with her hands on the steering wheel. Then she reached into the satchel, pulled out a small digital recorder, separate from the device in the lining, a backup she carried in her jacket pocket, and pressed stop. She labeled the file on its small screen. Calloway. Unsolicited contact, post-hearing, March B. She started the car and drove back to the hotel. She did not speed. She did not run yellow lights. She moved through Richmond traffic the way she moved through courtrooms, precisely, without drawing attention, every action selected for a purpose that would not become visible until later. Over the next 5 days, Angela filed 3 documents with the clerk's office. The first was a motion to reconsider the witness limitation, citing Virginia Rule of Evidence, Hai Chum Bon Kong Hai. All relevant evidence is admissible unless excluded by specific rule, and requesting that the court identify which rule justified reducing her witness list. The second was a formal discovery request to Commonwealth Property Holdings for all communications regarding her tenancy. The third was a request for the official transcript of the March 3rd hearing, accompanied by the standard transcript fee of $3.50 per page. The motion to reconsider disappeared. Not denied. Not returned. Disappeared. Angela filed it on a Tuesday at 9:12 a.m. through Piper Stokes's window. She received a time-stamped copy. She had insisted on it, standing at the window until Piper pressed the date stamp onto the document with visible annoyance. 3 days later, when Angela checked the case docket online, the motion was not listed. No entry, no notation, no record that it had ever been filed. She returned to the clerk's window on Friday. "I filed a motion on Tuesday, case number CL Gach Noi Hai, Không Hai Nam Gach Noi Không Bon Bon Một Bay. It's not appearing on the docket." Piper looked at her computer screen with the expression of a woman searching for something she already knew wasn't there. "I don't see anything filed since your original petition." "I have a time-stamped copy." Angela placed the document on the counter. The date stamp was clearly visible. March Bon, Hai Ngin Kong Trum Hai Mui Lum, Chin Zhou Mui Hai Fut Sang, Henrico County Circuit Court Clerk's Office. Piper looked at it the way a person looks at a parking ticket, acknowledging its existence without accepting its authority. Sometimes filings get misrouted. I'll look into it. Virginia Supreme Court Rule 1:17 requires the clerk to endorse the date of filing on every document received and to enter it on the docket within 1 business day. This document was received 5 days ago. Piper's expression did not change, but something behind her eyes shifted. A recalculation. Pro se litigants did not cite Supreme Court rules. They cited Google results. They cited what their cousin, who took 1 semester of paralegal classes, told them. They did not cite Rule 117 from memory. I said, "I'll look into it, Ms. Mercer." Angela nodded. She did not escalate. She photographed the time-stamped copy with her phone. In front of Piper, visibly, the camera shutter sound audible in the quiet office, wrote the date and time on an index card, and left. The motion appeared on the docket the following Monday. Filed date, March Bon. Docket entry date, March Moy, 6 days late, but now on the record. The delay, however, had already done its damage. Calloway filed a motion to strike Angela's submission as untimely, arguing that she had missed the 5-day response window. The motion was technically accurate if you ignored the fact that the delay was caused by the clerk's failure to process the filing. Angela did not ignore it. She filed a response attaching the time-stamped copy, the screenshot of the empty docket from March 7th, and a printout of Rule 117. She hand-delivered it, stood at the window, and watched Piper stamp it. "I'll need a filed copy returned to me today, please." Piper stamped the copy with a force that suggested the document had personally offended her. The social architecture of the courthouse shifted around Angela like weather. Piper Stokes operated as the hub of an informal network. Clerks, bailiffs, security guards, cafeteria staff, connected by proximity, habit, and the shared understanding that the clerk's office controlled access. If Piper decided you were a problem, the building decided you were a problem. The signs appeared within days. At the security checkpoint on the morning of March Moy, the guard, a heavy-set man with a crew cut and the bored expression of someone counting hours until pension, pulled Angela aside for a secondary screening. Her satchel went through the X-ray machine twice. Her phone was examined. The guard held her driver's license up to the light as though checking for counterfeiting, then asked her to step through the metal detector a second time. "Routine random check," he said, not looking at her. "Policy." The man in the suit behind her walked through without stopping. Angela collected her belongings without comment. The next morning, the same guard pulled her aside again, and the morning after that. By the 4th day, it was no longer pretending to be random. In the courthouse cafeteria, Angela set her tray down at a table near the window. The woman already seated there, a white woman in her 50s waiting for a family court hearing, glanced up, gathered her purse and coffee, and moved to another table without a word. The message was silent and complete. Angela ate alone. She was cutting into a dry chicken sandwich when a man at the next table, middle-aged, wearing a county employee badge on a lanyard, leaned over. "You're the one fighting Judge Meade, right?" His voice was low but not quiet enough. 2 women at the table beyond him turned their heads. "Word of advice, you're wasting your time and his. Meade's been on that bench longer than most people have been alive. You're not going to win." Angela looked at him. "I appreciate the concern." "It's not concern." The man picked up his tray. "It's a fact." He stood, paused, and added, loud enough for the nearby tables to hear, "Some people don't know when they're not welcome." He walked away. The 2 women at the far table exchanged a glance that confirmed they had heard, understood, and filed the exchange under the category of things that happened in this building that no one would later recall. The Wi-Fi password for the public areas was posted on a laminated sign near the attorney conference room. When Angela approached the sign on March Moy High, it had been covered by a sheet of paper reading, "Attorney Lounge, bar members only." The sign was new. The tape holding it was fresh. Angela used her phone's cellular data without comment. On March Moy Bay, the architecture of exclusion turned physical. Angela was walking toward the second-floor restroom, the only public one near the clerk's office, when she found the door propped open and Lindell standing in the frame, arms crossed, watching a maintenance worker push a dry mop across dry tile. The bucket beside him was empty. "Restrooms closed for cleaning." Lindell did not move. "Use the one downstairs." Angela looked past him. The floor was dry. The performance was not even convincing. How long will it take? As long as it takes. She walked to the first floor. That restroom was also closed, a handwritten sign taped to the door. Out of order. Angela pushed the door open. Every fixture worked. She used the restroom, washed her hands, and on her way out, peeled the sign from the door and folded it into her satchel. Another piece of paper, another index card, another timestamp joining the stack. The following afternoon, Wynne Calloway turned a hallway corner at the same moment Angela did, coming from opposite directions. The corridor was wide enough for 5 people to walk abreast. Calloway did not adjust his path. His shoulder drove into hers. Not a brush, not an accidental graze, but a full collision that knocked the satchel from her grip. It hit the marble floor with a crack that echoed off the walls. The clasp popped open. Index cards scattered across the tile like a deck of cards thrown from a table. "Excuse me?" Calloway's voice held the shape of an apology and none of its substance. He kept walking. Did not slow. Did not look back. Angela knelt on the marble floor of the Henrico County Courthouse and picked up index cards one by one. Attorneys walked past. A clerk stepped over a card without glancing down. A woman with a stroller navigated around Angela's knees without comment. No one stopped. No one offered a hand. Angela collected every card, checked under the wooden bench along the wall where 2 had slid, and stood. She brushed her knees. Her palms were gray from the floor dust. She pulled a fresh card from the satchel pocket and wrote, "March Moybon, Calloway. Physical contact, hallway. Satchel knocked from grip, contents scattered. Corridor unobstructed. No witnesses intervened." She adapted the way a person adapts to altitude, not by fighting the thin air, but by adjusting the depth of each breath. She brought her own lunch in a paper bag. She arrived early enough to pass through security before the guard was fully settled into his routine. She used her phone as a hotspot. She sat wherever the gallery's invisible rules allowed her to sit, and she watched. Smash that like button if you want to see these receipts come back to haunt every person in that courtroom. On March Muy High, something happened that would not seem significant to anyone who didn't know what Angela Mercer was doing in Henrico County. She was standing in the hallway outside courtroom 3, waiting for the afternoon session to begin, when the security guard approached for the 5th consecutive day of random screening. This time, he was more aggressive. "Ma'am, I need to check your bag." Angela held out the satchel. The guard, whose name badge read Deputy T. Frawley, took it from her with a motion that jerked the strap against her neck before pulling it free. He unzipped the main compartment, turned the satchel upside down, and shook it over the hallway bench. The contents rained out. Legal pad, pens, index cards, a granola bar, a water bottle, the manila folder, and the small backup digital recorder from her jacket pocket, which she had placed in the satchel that morning. The water bottle rolled off the bench and hit the floor, cracking its cap. Water pooled on the tile. "What's this?" Frawley picked up the recorder. "A digital recorder, for personal notes." Frawley turned it over in his hands. Then he set it down and picked up the manila folder. He opened it, began flipping through the complaint letters inside. 47 pages of other people's pain, each one redacted, each one private, each one now being thumbed through by a courthouse security guard who had no authorization to read them. "Those are personal legal documents." "I'm checking for contraband, ma'am." Frawley didn't look up. He held one of the complaint letters close to his face, reading it. Angela watched him read someone else's story, a woman describing how a judge had spoken to her, what he had said, how it had made her feel, with the idle curiosity of a person flipping through a magazine in a waiting room. "Recording devices aren't allowed in the courthouse without authorization," he said, setting the folder down on top of the spilled water on the bench. This was not accurate. Virginia law allowed recording in public areas of courthouses, and the courtroom itself was governed by the presiding judge's rules, which in Henrico County permitted personal recording devices for note-taking purposes, as long as they did not disrupt proceedings. The rule was posted on the courtroom door. Angela did not cite the rule. Not here, not to this man, not with her belongings scattered across a wet hallway bench and her private documents exposed to anyone walking past. I'd like my property returned, including those documents, which are protected under attorney-client. She stopped herself. She was not an attorney, not in this role. Which are personal legal documents. Frawley held the recorder for another 10 seconds, long enough to establish that he could, then set it on the bench beside her other items. He did not help her repack. He did not apologize for the water now seeping into the bottom of the manila folder. He walked away without a word. Angela gathered her belongings. The granola bar had been crushed, its wrapper split. The index cards were out of order. She reorganized them on the bench one by one, restoring the chronological sequence she maintained. Then she pulled a fresh card from the satchel's pocket and wrote, March 12th, Frawley, bag search, items dumped, recorder examined, false policy claim recording devices. She slid the card into its place and walked into courtroom 3. But something else had happened during the bag search that Frawley had not noticed. When he upended the satchel, the backup recorder had landed face up on the bench. It was running. The red light was on. It had been recording since Angela left the hotel that morning, a practice she had adopted on the third day of random screenings, pressing record before she locked the car door, letting the device capture the full audio environment of her courthouse experience. Frawley's words, "Recording devices aren't allowed in the courthouse without authorization," were now preserved in a digital file that would later be labeled Exhibit F3, authenticated by timestamp, location data, and the ambient noise signature of the second-floor hallway of the Henrico County Courthouse. Angela Mercer did not have a temper. She had a filing system. The second hearing, on March Moichin, began at 9:32 a.m. Angela stood at the petitioner's podium. Calloway sat at the defense table with a stack of motions that had grown since the first hearing. Judge Meade entered with the same practiced sweep, settled into his chair, adjusted his glasses. Ms. Mercer, I've reviewed your motion to reconsider the witness limitation. Meade's tone suggested he had reviewed it the way a person reviews junk mail, glancing at the envelope before discarding it. Denied. Angela had expected this. The denial itself was not the point. The point was what came next. I've also reviewed Mr. Calloway's motion for sanctions. Meade picked up a document. Mr. Calloway argues that your filing is frivolous and constitutes an abuse of process under Virginia Code Section 8.01-271.1. I'm inclined to agree. Angela's hand tightened on her pen, not from surprise, but from the controlled effort of keeping her voice level. Your Honor, I haven't had an opportunity to respond to the sanctions motion. I received it by mail on March 15th, and the response deadline under Rule 3:15 is Ms. Mercer. Meade's voice cut through hers the way a door cuts through a conversation. Total, abrupt, final. I've read the motion. I've read your filings. I'm not convinced you have a viable claim, and I'm not convinced you understand what you're doing in this courtroom. Your Honor, I'd like the record to reflect that I'm being denied the opportunity to respond to a sanctions motion before the court rules on it. That's a due process. Do not lecture me on due process in my courtroom. The words hit the room like a physical force. Meade leaned forward. His face had reddened. The gallery went silent. The same practiced silence Angela had observed in her first week. The silence of people who knew that this particular shade of anger preceded consequences. Angela stopped speaking. Not because she was afraid, because the man behind the bench was handing her exactly what she needed, word by word, and interrupting him would be like interrupting a confession. Meade continued, his voice tight with the particular fury of a powerful man who has been mildly inconvenienced by someone he considers beneath him. You have filed motions that waste this court's time. You have challenged procedures that are within my discretion. You have questioned the competence of court staff. If you continue on this path, Ms. Mercer, I will not only grant sanctions, I will refer you to the sheriff's office for obstruction of judicial proceedings. He turned to Calloway. Mr. Calloway, your sanctions motion is taken under advisement. I'll rule at the next hearing. Ms. Mercer, I suggest you use the time between now and then to reconsider whether you want to continue pursuing this matter without legal counsel. He looked at her, a long, measured look that was not about the housing case or the motions or the witness list. It was about hierarchy, about who held power in this room and who did not. His eyes moved over her face the way a person examines a piece of furniture he is considering discarding, assessing whether it has any remaining utility before consigning it to the curb. In the gallery, a woman in the third row leaned toward the man beside her and whispered something. The man shook his head. A court clerk in the front row typed on her phone under the desk, the screen glow visible in the dim light of the gallery. The room had an audience, and the audience had rendered its verdict before the judge rendered his. The black woman at the podium was a problem, and problems in Judge Mead's courtroom were resolved in one direction. Because people who come into my courtroom thinking they know the law, without training, without credentials, without any understanding of how this system works, they tend to leave with less than they came in with. Do you understand me? Angela understood him. She understood him more completely than any person in that courtroom, because she had heard 47 versions of this speech in 47 complaint letters that sat in a manila folder in her hotel room, each one describing a different day, a different name, and the same voice saying the same thing from the same bench. She understood that his contempt was not personal. It was structural, a load-bearing wall in the architecture of his authority, and she was documenting every brick. "I understand, Your Honor," she said, and she wrote in her notebook. The pen did not move fast. It moved at the speed of someone copying an address, careful, complete, legible, the kind of writing that would hold up under examination. The hearing lasted 11 minutes. Angela left the courtroom through the double doors, her legal pad containing 3 pages of new notations, her satchel containing audio that would be downloaded to a secure server within 24 hours, and her expression containing nothing at all. A blank surface that gave Mead and Calloway and Piper Stokes and the gallery exactly what they expected to see. A woman who had been put in her place. They were wrong about every part of that assessment, except the last word. She was in her place. She was exactly where she was supposed to be. She turned right toward the elevator bank and walked directly into a wall of muscle. Gage Lindell stood in the hallway, positioned between Angela and the elevators, with the casual precision of a man who had been told where to stand. He was 6'2", broad-shouldered, with the thick neck and flat eyes of someone who had been selected for this job because of his physical dimensions as much as his qualifications. His hand rested on his belt, not on his weapon, but close enough to communicate the proximity. "Ma'am, Judge Mead would like you to know that your behavior in the courtroom today was noted. I was exercising my right to respond to a motion. The judge feels you were being disruptive. I was speaking when called upon. That's not disruption." Lindell stepped closer. The hallway was wide enough for 5 people to walk abreast, but his body language compressed the space until it felt like a corridor. He placed one hand flat against the wall beside Angela's head, not touching her, but close enough that she could smell the coffee on his breath and the metal polish on his badge. "Ma'am, I'd like to escort you to the exit. I have business with the clerk's office." "The clerk's office is closed for the judge's lunch recess." This was not true. Angela could see, past Lindell's shoulder, the light on in Piper's window. But arguing with a man who stood 6 inches taller and outweighed her by 100 pounds, who had positioned his arm to cage her against the wall in a hallway where the nearest witness was 50 feet away, was not a calculation she was willing to make. "Step back, please. You're in my personal space." Lindell did not step back. He held the position for 3 full seconds, long enough to establish the dynamic, long enough for Angela to feel the weight of his proximity as a physical thing pressing against her chest. Then he dropped his arm and stepped aside, the motion carrying the casual menace of a man who wanted her to understand that the space she occupied was his to give or take. "After you." She turned toward the stairs. Lindell followed, not beside her, but 2 steps behind, the way a guard follows an inmate. His boots on the marble floor set a rhythm that accompanied her down one flight and through the first-floor lobby. At the main entrance, he stopped. "Have a good afternoon, Ms. Mercer." She walked to her car without looking back. Inside the Nissan, she sat with her hands on the steering wheel for 20 seconds. Then she opened the satchel, pulled out the recorder, and pressed stop. 4 days later, the transcript of the March Mui Chin hearing arrived. Angela had paid for expedited processing. The document was 42 pages, typed single-spaced, certified accurate by court reporter Nolan Voss, whose signature appeared on the final page in blue ink. Angela sat at the hotel desk with the transcript on one side and her laptop on the other, the audio recording from the satchel device playing through earbuds. She read the transcript line by line, comparing each entry to the audio. Page 1. Case called, Attorneys Identified, Preliminary Matters, accurate. Page 2 through 5. Callaway's Arguments, accurate, though slightly condensed. Page 6. Meade's ruling on the motion to reconsider, accurate. Page 7. The audio. Do not lecture me on due process in my courtroom. The transcript, page 7, line 14. The court reminded the petitioner of proper courtroom decorum. Angela paused the recording, reread the line, played the audio again. The words were not the same. They were not close. One was an outburst, loud, personal, loaded with the kind of contempt that courts existed to prevent. The other was a sanitized summary that could have described a judge politely correcting a procedural misstep. She continued. Page 9. The audio. People who come into my courtroom thinking they know the law, without training, without credentials, without any understanding of how this system works, they tend to leave with less than they came in with. The transcript, page 9, line 21. The court advised the petitioner regarding the complexities of self-representation. Angela set down her earbuds. She pulled the transcript of the March 3 hearing from the satchel, the one she had received the previous week, and opened to page 14. The audio from March 3. People like you always think you understand the law. The transcript, page 14, line 7. The court addressed the petitioner regarding procedure. 3 hearings worth of audio, 3 sets of transcript pages, 3 systematic rewrites of what had actually been said in courtroom 3, each one replacing the judge's actual words with a version so bland it could have come from a textbook. Angela opened a new document on her laptop. She titled it, Transcript Comparison, C.L. Gach Neuhai, Kong Hainam Gat Noi, Kong Bon Bon Mot Bay, Discrepancy Analysis. She created a 3-column table, page and line number, official transcript text, actual audio text. She began filling it in. By midnight, the document was 7 pages long. It contained 18 discrepancies across 2 hearing transcripts. Some were minor, word substitutions that softened Meade's tone. Others were material, complete omissions of statements that, if preserved accurately, would constitute evidence of bias, prejudice, and judicial misconduct. She saved the document, backed it up to an encrypted drive. Then she opened Virginia Code Section 8.01-4, 20.4, the statute governing transcript corrections, and drafted a formal request for the court to amend the official record. The request was filed the next morning. It landed on Nolan Voss's desk like a grenade. March Hai Muy Bon, 5 days before the sanctions hearing. Angela arrived at the courthouse at 8:15. She passed through the security checkpoint. Frawley pulled her aside, searched her bag, found nothing remarkable, and waved her through with the sullen efficiency of a man performing a task he had been told to perform without understanding why. Angela collected her satchel, reorganized her index cards, and walked to the second floor. The door to courtroom 3 was closed. A paper sign taped to the glass read, Courtroom closed for maintenance. All hearings relocated to courtroom 1. Angela walked to courtroom 1 at the opposite end of the building. The door was open. Inside, a different hearing was already in progress. A contract dispute, attorneys on both sides, no connection to her case. She checked the docket posted outside the door. Her case was not listed. She went to the clerk's window. My hearing was scheduled for courtroom 3 at 9:30. The courtroom is closed. Where has it been relocated? Piper looked at her computer screen. I show your hearing on the 26th, Ms. Mercer, not the 24th. My notice says the 24th. Angela produced the notice, the one mailed to her by the clerk's office, date-stamped, showing March High Muy Bon at 9:30 a.m. in courtroom 3. Piper examined it with the same theatrical slowness she applied to all of Angela's documents. That appears to be an error. The hearing is the 26th. The notice is dated March 15th. If the date was changed, I should have received an amended notice under Virginia Code Section 8.01-227.8. Piper's mouth thinned. I'll check with the judge's office. I'll wait. Angela waited. 40 minutes. Standing at the clerk's counter while Piper made 2 phone calls, shuffled papers, helped 3 other people, and refilled her water bottle. At 10:12, Piper returned to the window. Your hearing has been confirmed for March 26th, 9:30 a.m., courtroom 3. And the original notice showing March 24th? Clerical error. It happens. Angela photographed the original notice, wrote the date, time, and Piper's statement on an index card, slid it into the satchel. On her way out, she passed Nolan Voss in the hallway. He was carrying a folder, the kind used for court filings, and he saw her at the same moment she saw him. His face did something complicated. Not guilt, exactly. Awareness. The look of a man who knows that a document on his desk has the potential to end his career, and that the woman who filed it is now standing 8 feet away. He walked past without speaking. Angela walked past without speaking. 2 people who understood exactly what was at stake, passing each other in a hallway where the fluorescent lights hummed and the floor smelled of wax, and the building continued its daily business of sorting human lives into categories marked sustained and overruled. That afternoon, Angela sat in the gallery of courtroom 3, open again, the maintenance sign gone, and watched Meade preside over 3 cases. In the second case, a landlord-tenant dispute, the tenant was a black woman in her 30s named, according to the docket, Carla Williams. She had 2 children with her, a girl of about 10 and a boy of about 7, sitting in the gallery row behind the bar. Williams asked for a continuance. She had been trying to find legal representation. 3 attorneys had told her they couldn't take the case. Legal aid was overbooked, and private counsel wanted a retainer she couldn't pay. Your Honor, I've been trying to get a lawyer. I just need 30 more days. Meade looked at her the way a person looks at an obstacle in a doorway, something to be moved, not engaged with. You've had 30 days, Miss Williams. This court has a schedule to keep. I understand, Your Honor, but the housing authority said my file was... Ms. Williams, I'm not the housing authority. I'm the court. Your landlord has filed for possession. You've produced no evidence of lease compliance. Continuance denied. Judgment for the plaintiff. The gavel came down before Williams could finish her sentence. The whole proceeding, from case called to judgment entered, lasted 4 minutes and 11 seconds. Angela timed it on her watch. Williams stood at the podium for a moment, the paper in her hand, whatever document she had brought, whatever proof she thought would matter, trembling at its edges. Then she turned and walked up the aisle. Her daughter stood as she approached, took her mother's hand. The girl's face was tight, controlled, an expression too old for 10 years. She looked back at the judge's bench, one long look, not childlike at all. It was the expression of a person who was learning, earlier than she should, that some rooms were not designed to help people like her. The boy tugged on his sister's jacket, confused. She guided him out. Williams did not look back. Angela wrote in her notebook, 3 lines, date, time, 4 minutes and 11 seconds. On her way out of the courtroom, Angela held the door for a white woman entering. The woman stopped, looked at Angela, then at the door she was holding open, and walked to the other door, the one 3 feet away, still closed, opened it herself, and entered through it. The message was small and would be invisible in any transcript, any record, any filing. But Angela felt it the way a person feels a paper cut, precise, thin, and deeper than it looks. She took the stairs to the 2nd floor. In the hallway near the clerk's office, she encountered Piper Stokes walking in the opposite direction. Piper slowed, but did not stop. "Still here, Ms. Mercer?" The question was not curious. It was diagnostic. Piper checking vital signs, measuring how much fight was left. Most pro-C filers quit after the first sanctions threat. I'm persistent. Persistent. Piper repeated the word the way a doctor repeats a symptom, noting it, not approving it. Judge Meade has a word for that. I believe he's already shared it with you. She continued walking, her heels clicking a rhythm on the marble that sounded, to Angela, like a countdown. That evening, back at the hotel, Angela pulled out her phone and dialed the contact labeled RH. It rang twice. Go ahead. The voice on the other end was male, middle-aged, with the clipped cadence of someone accustomed to secure communications. I have enough for the preliminary report. 4 hearings observed, 2 as a party. 3 transcript alterations documented with audio comparison. 1 use-of-force incident by courthouse security, Deputy Frawley, bag search with items dumped, false policy citation regarding recording devices. 1 physical intimidation incident, Deputy Bailiff Lindell, post-hearing hallway encounter. 1 filing manipulation, Clerk Stokes, 3-day delay with docket omission, confirmed by time-stamped copies. Hearing date changed without notice. A pause, the sound of writing. Timeline for the final hearing? March 26th, sanctions motion. If he rules without hearing my response, which he's already indicated he will, that completes the procedural chain. Denial of due process, pattern evidence, and judicial bias across 4 documented sessions. The transcript corrections? Filed. No response yet from the court reporter. I expect either an amended transcript or a refusal. Either one serves the evidentiary record. Another pause. Longer this time. Be careful. If anyone in that courthouse identifies you before the filing, the entire investigation is compromised. Meade's had 22 years to build relationships in that building. If Stokes or Voss or anyone else tips him off, they won't. Angela's voice carried the certainty of a woman who had done this before. He's too confident to suspect. That's the whole point. She hung up, set the phone on the desk, looked at the manila folder with its 47 complaint letters, each one representing a person who had stood where Angela now stood and had no one listening. The phone call would later be referenced, though not in detail, in the official timeline of the investigation. The contact labeled RH was Raymond Hess, whose title and affiliation would not become public until the formal hearing. For now, he was a voice on a phone, a thread connecting Angela Mercer to something larger than a housing dispute in Henrico County. She didn't know, sitting in that hotel room on March High Muy Bon, that the timeline was about to accelerate, that Piper Stokes had already begun making calls of her own, that the question Piper had asked Calloway 3 days earlier, "She's too calm, she knows too much," had not been idle gossip but a genuine alarm, the instinct of a gatekeeper who sensed that the gate was no longer holding. And she didn't know that the sanctions hearing on March High Muy Sao, the hearing she had been calibrating every action toward, the hearing that would complete the evidentiary record she needed, was about to become something far more dangerous than a ruling on attorney's fees. Because Gage Lindell had been given new instructions, and the next time he put his hands on Angela Mercer, it would not be a hallway escort. The morning of March High Muy Sao arrived with the kind of sky that Virginia produces in late March. Gray, heavy, not yet raining, but promising it. Angela dressed in the same navy blazer, the same flat shoes. She checked the recorder in the satchel lining. Battery at 87%, storage at 62% capacity. She checked the backup recorder in her jacket pocket. Functional. She checked her phone, camera app accessible with one swipe, voice memo running in the background since she'd left the parking lot. 3 recording devices. 3 separate evidence streams. She had learned, in 11 years and 9 states, that redundancy was not paranoia. Redundancy was professionalism. She arrived at the courthouse at 8:22. The security line was longer than usual. Frawley was at the checkpoint, but this time he waved her through without the secondary screening. This was not a kindness. It was a recalibration. Someone had told him to stop drawing attention to the pattern. Angela noted the change on an index card. Courtroom 3 was already open. The gallery held more people than usual for a 9:30 hearing. 12 observers, where there were normally 3 or 4. Angela recognized two of them from previous hearings. The others were new. She did not know their faces, but she knew the composition. People who had heard, through the courthouse network, that something was happening in the Mercer case. Not because they cared about housing disputes, because they cared about the spectacle of a black woman who had refused to be quiet. She took her seat at the petitioner's table, satchel on the table, legal pad open, pen ready. Calloway arrived at 9:25, later than usual. He set his briefcase down without greeting Angela. His expression was different today, not smug but watchful. Something had shifted in his calculation. Angela noted it without reacting. At 9:31, the bailiff called order. Meade entered, settled, adjusted his glasses. But today, he did not scan the room with his usual casual authority. Today, his eyes found Angela immediately, a direct look that held for 2 full seconds before he turned to the clerk. Case number C. L. Gotch, Noi Hai, Kong Hai Numgat Noi, Kong Bon Bon Mot Bay. Piper's voice carried its usual administrative flatness. Mercer versus Commonwealth Property Holdings. Sanctions hearing. Meade opened a folder on his bench. Ms. Mercer, I've reviewed the pending sanctions motion. I've also reviewed your recent filing requesting transcript corrections, which I'm treating as frivolous and potentially sanctionable in its own right. Angela stood. Your Honor, I'd like to respond to the sanctions motion before the court rules. I have not yet been given an opportunity to... Your response is on file, Ms. Mercer. Meade held up a document. I've read it. Your Honor, the response I filed addresses the original sanctions motion. Since then, the court has indicated it may impose additional sanctions related to the transcript correction request. I haven't been served with any motion regarding those additional sanctions, and I've had no opportunity to respond. I'm ruling on both matters now. Your Honor, due process requires... Ms. Mercer. Meade's voice dropped to the register he used when he was about to end a conversation. I have been more than patient with you. You have filed motions that waste this court's time. You have accused court staff of mishandling documents. You have alleged, without evidence, that official transcripts are inaccurate. You have demonstrated a pattern of obstruction that I will no longer tolerate. He picked up his pen. Sanctions in the amount of $2,500, payable within 30 days. Case dismissed with prejudice. And Ms. Mercer, I am referring your conduct to the Henrico County Bar for review. Angela stood at the podium. Her legal pad was open. Her pen was in her hand. The courtroom was silent except for the hum of the overhead lights and the barely audible click of Nolan Voss's keys, which had, she noticed, stopped moving during Meade's speech and resumed only now. She could have argued. She could have cited the statute, challenged the ruling, demanded the record reflect the denial of her right to respond. All of those actions were available to her, and all of them would have been correct. Instead, she closed her notebook. She placed her pen in the satchel. She gathered her legal pad, her copies, the water bottle she hadn't opened. She stood straight, her posture unchanged from the moment she'd entered the room. Thank you, Your Honor. Her voice was level, unhurried. That's all I needed. Meade's pen stopped. For 1 second, barely perceptible, but Angela had spent 3 weeks learning to read this man's face. Something crossed his expression that was not anger or contempt, but uncertainty. A flicker. The faintest recognition that the words she had just spoken did not belong in the mouth of a woman who had lost. The moment passed. Meade looked down at his papers. The gavel fell. Angela walked up the aisle, slowly, not the walk of a person retreating, the walk of a person leaving a room where their work is finished. She reached the double doors, pushed through. Lindell was waiting. He stood in the hallway like a wall, feet planted, arms at his sides, blocking the path to the elevators with his body. 2 other deputies stood behind him, flanking the corridor. The arrangement was deliberate, triangulated, the kind of positioning designed to prevent movement in any direction. Ms. Mercer, Lindell's voice was flat. Judge Meade has requested that I escort you from the building. I'm leaving voluntarily. I need you to hand over your satchel. Angela's hand tightened on the strap. On what grounds? Courthouse security policy. We need to inspect your belongings before you leave the premises. This was not a policy. Angela had exited this building 14 times over 3 weeks without a departing inspection. But the hallway was empty of witnesses, except the 2 deputies who stood behind Lindell with the practiced blankness of men following orders they did not intend to question. I'd like to see the written policy. Lindell stepped forward. Not a step. A lunge. His right hand closed around the satchel strap at Angela's shoulder, twisting it, and his left hand clamped onto her upper arm above the elbow with a grip that compressed muscle against bone. He yanked the strap. It caught on Angela's neck, dragged across her throat before sliding off her shoulder. The satchel came free. Lindell tossed it behind him to one of the deputies, who caught it with both hands like a man receiving a football. Angela's arm throbbed. The same arm. The same spot. The bruise from the March Moychin incident had barely faded to yellow at the edges. This grip was harder, Lindell's fingers digging into the tissue with a pressure that sent a bolt of pain from her shoulder to her fingertips. You're hurting me. Ma'am, please cooperate. Lindell's other hand closed around her right wrist. Not a grip, a lock. Thumb pressing into the tendons on the underside of her wrist, the kind of control hold taught in defensive training, but never intended for use on a compliant woman carrying a briefcase. Her fingers went numb. She felt the bones in her wrist shift under the pressure. He turned her body, spinning her toward the staircase with the mechanical efficiency of someone who had practiced this on training dummies, and had decided that the distinction between a training dummy and a black woman in a courthouse hallway was negligible. Her shoulder popped. Not dislocated, but the joint protesting the angle at which it was being held. A gasp escaped her throat before she could stop it. The 2 deputies fell in behind. A formation. 3 large men and 1 woman, moving through the second-floor hallway of a public building in a configuration that, from a distance, looked like an arrest. Angela did not resist. She did not pull away, did not raise her voice, did not give Lindell the reaction that would justify, in any incident report, on any camera, in any hearing, the escalation of force. She walked where he directed her. Each step jarred the grip on her arm and wrist. The pain was steady now, a dull roar beneath the sharper spikes where his fingers found nerve clusters. They passed Piper's window. Angela turned her head. Instinct, or strategy, or both, and caught Piper Stokes watching through the glass. Piper's expression was not shocked. It was not sympathetic. It was the expression of a woman observing a transaction she had arranged, confirming that the terms were being met. Their eyes locked for 1 second. Piper looked away first, down the stairs. Lindell maintained the grip on each step, using the angle of the descent to keep Angela slightly off balance, her weight dependent on his hold rather than her own footing. At the landing between floors, he shoved her forward, a push that sent her stumbling 3 steps before she caught herself on the railing. Her palm slapped the metal. The sound echoed in the stairwell. Watch your step, ma'am. Through the first-floor lobby, past the information desk, where the woman with the bifocals, the same woman who had directed Angela to family court on her first day, sat with her hands folded and her eyes fixed on a point 6 inches above Angela's head. Seeing everything. Witnessing nothing. The distinction between those 2 states was the foundation on which the Henrico County Courthouse had operated for decades. Out the front doors. The March air hit Angela's face, cold and clean after the recycled atmosphere of the building. Lindell released her wrist. The deputy set the satchel on the concrete steps at her feet. The zipper was open. The contents had been rifled, index cards out of order, the legal pad's pages bent, the manila folder visible at the top where it had been pulled partially out and shoved back in. The water-damaged complaint letters from Frawley's search 2 weeks earlier were crumpled further, their edges curling. "Have a good day, Ms. Mercer." She stood on the steps for 30 seconds after they went inside. The March air was cold on her skin. Her left arm ached from shoulder to elbow. Her right wrist bore the red imprint of Lindell's thumb, already darkening at the edges. The satchel sat at her feet, its contents displaced, its order violated. She bent down, picked it up, opened the front pocket. The backup recorder was still there. They had either missed it or not known what it was. She checked the satchel lining. The primary device was still in place, its indicator light steady. Both recorders had been running. She walked to her car. She sat in the driver's seat. She did not cry. She did not shake. She took her phone from her jacket pocket, opened the camera, and photographed her left arm, the fresh bruising already visible over the yellow remnants of the previous injury, and her right wrist, where Lindell's thumbprint was developing in purple against her brown skin. Then she drove to the MedExpress Urgent Care on West Broad Street, where a physician named Dr. Karen Liu documented contusions on the left upper arm and right wrist, took clinical photographs for the medical record, and noted in her chart, patient reports injuries sustained during physical contact by courthouse security personnel. Contusion pattern consistent with forceful grip. No fracture on examination. Patient declined pain medication. Patient requested copies of all documentation. Angela left the clinic at 11:42 a.m. She drove back to the hotel. She sat at the desk. She opened the laptop. And she began to write the document that would end Judge Lowell Mead's career. The filing would not go out today. There were procedures, authentication, review, approval chains. The evidence needed to be compiled, organized, verified. The audio recordings needed to be downloaded to the secure server, their integrity confirmed by digital forensic analysis. The medical records needed to be incorporated. The transcript comparisons needed to be finalized. The 47 complaint letters needed to be cross-referenced with the patterns she had personally documented. All of that would take weeks. And after the filing, the hearing itself would take months to schedule. The machinery of judicial accountability moved at a pace that would frustrate anyone who expected justice to be swift. But the evidence was complete. 4 hearings, 18 transcript discrepancies, 2 use-of-force incidents with medical documentation, 1 filing manipulation with time-stamped proof, 47 prior complaints establishing a 14-year pattern, and audio recordings, hours of them, capturing the voice of a man who believed no one with consequence was listening. Angela's phone buzzed. A text from a number she didn't recognize. She opened it. The message contained a single photograph. A courthouse complaint form, dated Haingin Kongchummuibon, bearing the name of a petitioner she had never seen in any file. The complaint alleged that Judge Mead had dismissed a custody case without hearing testimony from the mother, a black woman, and awarded sole custody to the father, who was represented by Wynne Calloway. The form bore a stamp in the upper right corner, "Received, Clerk's Office." Beneath the stamp, in handwriting she did not recognize, a single word: more. Angela stared at the photograph. She did not recognize the handwriting. She did not recognize the phone number. She did not know who, inside that courthouse, had decided to start sending her evidence, or why they had chosen now, after 3 weeks of watching her be searched, intimidated, removed, sanctioned, and escorted from the building by a man who left bruises. But she knew what the photograph meant. It meant the 47 complaints in her file were not the full count. It meant there were files that had not been forwarded to her agency, complaints that had been buried deeper than the ones she already had, cases that had been handled so quietly that even the official complaint process had not captured them. It meant Piper Stokes had not merely failed to process complaints, she had actively disappeared them. And if that was true, it wasn't negligence. It was obstruction, a separate crime, a separate investigation, a thread that reached beyond the scope of anything Angela had been authorized to pursue. It also meant someone inside that courthouse, someone close enough to the filing system to access archived complaint forms, someone brave enough or desperate enough to send them to a stranger's phone number, had been watching Angela the same way Angela had been watching Mead, studying her, testing her, waiting for the right moment to hand her a piece of the puzzle she didn't know she was missing. The investigation she had come to Henrico County to conduct was larger than anyone had anticipated, and the person who sent this photograph wanted her to know it. She saved the photograph, backed it up, wrote the date, time, and source on an index card. March Haimui Sao, anonymous text, complaint form, Haingin Kongchummuibon, custody case, Meadgach Chao Calloway, sender unknown, and slid it into the satchel beside the others. The stack of index cards was thick now. 3 weeks of timestamps, names, violations, patterns. A paper trail built one card at a time by a woman who had been searched, shoved, silenced, sanctioned, and escorted from a building by men who left bruises on her arms and assumed that bruises were the end of the conversation. They were not the end. They were the evidence. Angela sat in the quiet of the hotel room, her left arm aching, her right wrist bruised, her satchel containing enough documentation to trigger a judicial conduct hearing that would shake the foundations of a courthouse that had operated without accountability for 22 years. Share this story with someone who needs to hear it, because the next one is even bigger. Outside the window, the Virginia sky had gone fully gray, the clouds low and heavy with a rain that had been threatening all day but refused to fall. Angela looked at the sky for a long time. Then she looked at the anonymous text message on her phone. Then she looked at the satchel on the desk, battered, rifled through, its contents displaced by hands that had no right to touch them but still holding everything she needed. She opened her laptop again. She had a report to write. And somewhere in a building on East Parham Road, a man in a black robe was sitting in chambers, reviewing his calendar, confident in the knowledge that the woman he had sanctioned and humiliated that morning would never be seen in his courtroom again. He was right about that. The next time Angela Mercer appeared in a proceeding involving Judge Lowell Mead, it would not be in his courtroom. It would be in a hearing room in Richmond, where 7 commissioners sat behind a long table, where the seal on the wall read, Virginia Judicial Inquiry and Review Commission, and where the man who had told her that people like you didn't understand the law would discover, too late, far too late, that she understood it better than he ever had. But that hearing was weeks away, and between now and then, the evidence she had gathered would travel through channels he didn't know existed, reviewed by people whose names he had never heard, building toward a reckoning he could not imagine, because he had spent 22 years believing that the rules he enforced on others did not apply to him. The rain finally came. It hit the hotel window in thick drops that slid down the glass like sentences being erased from a page. Angela watched it for a moment longer. Then she turned back to her laptop, set her bruised hands on the keyboard, and began typing the preliminary investigation report that would, in 6 weeks' time, arrive in Judge Lowell Mead's chambers in a sealed envelope. Return address, Virginia Judicial Inquiry and Review Commission, Richmond. She typed steadily. She did not hurry. She had been doing this for 11 years, and she had learned that justice did not reward speed. It rewarded accuracy. It rewarded patience. It rewarded the willingness to sit in a room where you are being humiliated and write down every word, not because you enjoy it, but because someone has to. Because 47 people wrote letters that went nowhere, and someone has to make the 48th count. Somewhere in the distance, thunder rolled across the Virginia Piedmont. Angela did not look up. She kept typing. The cursor blinked. The words accumulated. And the case against Judge Lowell Mead, built not on authority or rank or the power of a title, but on the meticulous, exhausting, unglamorous discipline of writing things down, grew by another page, and another, and another. The weeks after the sanctions hearing moved at 2 speeds. Inside the Henrico County Courthouse, time continued at its usual pace. Cases called, motions filed, judgments entered, the machinery of local justice grinding through its daily inventory with the indifference of a mill processing grain. Judge Lowell Mead presided over Courtroom 3 as he had for 22 years, adjusting his glasses, leaning back in his chair, interrupting litigants mid-sentence with the casual authority of a man who had never been told no by anyone who mattered. Outside the courthouse, in channels he did not know existed, time moved differently. Angela Mercer sat at the desk in her hotel room on the night of March Haimwisau and typed for 6 hours. The preliminary investigation report was not a narrative. It was a structure. Evidence organized by category, cross-referenced by date, linked to supporting documentation that would be submitted as exhibits. Audio recordings indexed by timestamp and content. Transcript comparison charts. Medical records. Photographs. Filing logs. The 47 complaint letters, each one cataloged by date, complaint type, and resolution, or, more accurately, Non-resolution, since all 47 had been dismissed. She finished at 3:17 a.m., saved the document, backed it up to the encrypted drive. Then she opened a separate file, the one she had started after receiving the anonymous text, and added a notation. Possible additional complaints not included in JIRC referral file. Source unknown. Authentication pending. The next morning she did not go to the courthouse. She drove instead to the Virginia Judicial Inquiry and Review Commission offices on East Main Street in Richmond, a building that, from the outside, looked like any other state office. Brick facade, glass doors, the kind of institutional architecture that communicated authority through blandness rather than grandeur. She parked in the visitor lot, walked through the metal detector at the lobby entrance, and took the elevator to the 4th floor. Raymond Hess was waiting in Conference Room B. He was 53, gray at the temples, with the physique and posture of a man who had spent 2 decades in federal law enforcement before transitioning to state oversight work. His desk held 2 monitors, a stack of case files, and a coffee mug that read, "Due process is a process," in faded letters. He did not stand when Angela entered. He was already reading. 18 transcript discrepancies. Hess turned a page. 2 documented use-of-force incidents, filing manipulation with time-stamped proof, and 47 prior complaints over 14 years, all dismissed internally. He looked up. The complaint processing issue alone could trigger a separate investigation. Angela sat across from him. She set the satchel on the table. The same satchel, still carrying the scuffs and water stains from 3 weeks of courthouse encounters. She opened it and removed the encrypted drive, the backup recorder, and the index cards, 114 of them, organized by date, each one a timestamp in the life of a woman pretending to be someone she was not. The audio files are indexed. I've included a comparison chart for the transcript discrepancies. Official text versus recorded audio, page and line number for each. She slid a printed document across the table. The medical records from MedExpress are attached. Dr. Karen Liu documented contusions consistent with forceful grip on 2 separate visits. Clinical photographs are in the file. Hess flipped through the comparison chart. His expression did not change, but Angela had worked with him long enough, 4 investigations over 6 years, to read the slight tension at the corner of his jaw. He was angry, not at her, at the document, at the gap between what a court reporter had sworn was accurate and what a recording device had captured. Voss certified these transcripts under oath. Twice, March 3rd and March 19th. His signature is on both. That's perjury territory. Virginia Code 18.2-471. And falsification of public records under 18.2-111. The transcripts are official court documents. Hess set the chart down. He looked at her, not the way Meade had looked at her, not the way Lindell or Frawley or Piper Stokes had looked at her, the way a colleague looks at another colleague after a difficult operation, assessing damage, checking for cracks. "How are you?" Angela's left arm still ached when she lifted it above her shoulder. Her right wrist still bore a faint purple shadow where Lindell's thumb had pressed into the tendon. She had slept 4 hours in 3 days. She had eaten gas station sandwiches and hotel coffee for 3 weeks. She had been searched, shoved, shoulder-checked, frozen out of restrooms, mocked in a cafeteria, and told by a man in a black robe that people like her didn't understand the law. "I'm fine." She pulled the index cards from the satchel. These need to be logged into the evidence file. Each card is dated, timed, and describes a specific interaction. They corroborate the audio records and provide context that the recordings alone may not capture. Hess took the cards. He did not push the question. He knew, from 4 investigations over 6 years, that Angela Mercer processed operational stress the way she processed evidence. Systematically, after the fact, in a controlled environment where vulnerability would not compromise the work. "I need one more thing." Angela reached into the satchel and pulled out her phone. She opened the anonymous text from March Hai Moi Sao, the photograph of the Haingin Kong Trum Moi Bon complaint form, the one with the single word "more" written beneath the clerk's stamp. This arrived after the final hearing. I don't know the sender. The phone number is unlisted. Hess studied the photograph. His jaw tightened further. Callaway is the opposing counsel in both cases, the one you filed and this one from Haingin Kongtrum Muibon. I noticed. If Stokes was processing complaint dismissals and Callaway was benefiting from Meade's rulings across multiple cases, that's a conspiracy pattern. Not just misconduct, corruption. I'm aware. But the scope of my assignment is judicial conduct. The conspiracy angle requires a separate authorization. Hess set the phone down. He looked at the wall for a moment, the kind of pause that, in a man like Raymond Hess, meant he was calculating the distance between what his job allowed and what justice required. I'll flag it in my report. Let the commission decide the scope. Angela nodded. She gathered her materials, leaving the encrypted drive and the index cards with Hess for processing. The audio files would be downloaded to the JIRC secure server, their integrity verified by SHA, Haitrumnum Mui Sauhash, their chain of custody documented from the moment Angela pressed record in a hotel parking lot to the moment Raymond Hess logged them into the evidence management system. The process would take weeks: authentication, review, internal legal analysis, drafting of the formal complaint, commission vote on whether to proceed to a hearing, notification to the respondent, Judge Meade, with 30 days to retain counsel and prepare a response. Scheduling of the hearing itself, which required coordination among 7 commissioners, 2 staff attorneys, a court reporter, and the respondent's legal team. Justice did not reward speed, it rewarded accuracy. Angela had learned this in 11 years and 9 states, in courtrooms where she had been insulted, threatened, and physically handled by men who assumed that the absence of a title meant the absence of authority. She had learned it in hotel rooms at 3 a.m, typing reports that would take months to produce results. She had learned it in the faces of the 47 people whose complaints had been filed, stamped, and buried in a system that processed their pain with the efficiency of a paper shredder. She had learned it, and she had not stopped believing in it. That was the part that surprised her sometimes. Not the corruption, not the cruelty, not the calculated indifference of a man like Meade. What surprised her was that she still believed the process worked. Slowly, imperfectly, with a margin of error that left room for people to fall through. But it worked. She drove back to the hotel, packed her suitcase, checked out, drove the rental car to the return lot at Richmond International Airport, and caught a flight back to Norfolk, where she lived in a 2-bedroom apartment with a cat named Verdict and a bookshelf organized by jurisdiction. The next phase of the investigation would happen without her. The machinery was in motion. The evidence was in the system. The commission would review, deliberate, and decide, and she would wait, the way she had waited 100 times before, for a phone call that would tell her whether the truth she had gathered was enough. 6 weeks passed. In Henrico County, Judge Meade continued to preside. He did not know that Angela Mercer's name had appeared in a document filed under seal in the offices of the Virginia Judicial Inquiry and Review Commission. He did not know that his transcripts, the ones Nolan Voss had certified as accurate, had been compared, line by line, against audio recordings that captured every word he had spoken in Courtroom 3 during the month of March. He did not know that his court reporter was already the subject of a separate inquiry, or that his clerk's complaint processing practices had been flagged for review, or that a deputy bailiff named Gage Lindell was mentioned by name in a medical report documenting injuries sustained during courthouse security interactions. He knew only that the Mercer case had been dismissed, that the sanctions had been paid. Angela had paid them from the investigation's operational budget, a detail that would later appear as a line item in the JIRC's annual report, and that the troublesome woman with the satchel had not returned to his courtroom. He considered this a victory. On May 8th, a Thursday, Judge Meade arrived at his chambers at 8:15 a.m. His secretary had placed the morning's correspondence on his desk in the order she always used: personal letters on top, official correspondence in the middle, junk at the bottom. The stack was unremarkable. A memo from the court administrator, a notice about a judicial conference in Williamsburg, a letter from the Virginia State Bar regarding continuing education credits, and an envelope, cream-colored, heavy stock. The return address printed in small, precise type: Virginia Judicial Inquiry and Review Commission, Mot Trum East Main Street, Suite Num Trum, Richmond, Virginia, Hai Bahai Mot Chin. Meade picked up the envelope. He held it for a moment, not reading the return address yet, just feeling the weight of it, the formality of the paper, the sealed flap that had been affixed with a gold sticker bearing the commission seal. Then he read the return address. Then he read it again. His secretary, watching through the open door, because she always watched, because 22 years as a judge's secretary had taught her to read the weather before anyone else, saw his hand stop moving, saw the color shift in his face, not draining exactly, but receding, the way water recedes from a shoreline before a wave. He opened the envelope with a letter opener. He read the first paragraph. He read the second paragraph. He set the letter on his desk, placed both hands flat on either side of it, and stared at the wall for 45 seconds. Then he picked up his phone and called his attorney. The formal hearing was scheduled for June 19th, 6 weeks after notification. It would take place not in the Henrico County Courthouse, Meade's territory, Meade's bench, Meade's rules, but in the JIRC hearing room in Richmond, a wood-paneled chamber with 7 chairs behind a long table, a witness stand, and a seal on the wall that bore the words Commonwealth of Virginia above the scales of justice. 7 commissioners, 2 retired judges, 3 attorneys, 1 law professor, 1 citizen member, all appointed by the Virginia Supreme Court, none of them beholden to the Henrico County political structure that had sustained Meade's career for 2 decades. The hearing room filled at 9 a.m. on a Thursday that was unseasonably warm, the kind of Virginia June morning that made everything, suits, patience, pretense, slightly too heavy to wear comfortably. The gallery held 12 observers, 3 reporters, 2 attorneys from the Virginia State Bar who were there in an unofficial capacity, a representative from the ACLU's Virginia chapter, and 6 members of the public who had read about the hearing in the Richmond Times-Dispatch's legal column and decided to show up. Meade sat at the respondent's table with his attorney, Harold Crenna, a veteran defense lawyer who specialized in judicial conduct proceedings and whose hourly rate reflected the severity of what his clients typically faced. Crenna had a yellow legal pad, 3 binders of prepared materials, and the expression of a man who had reviewed the evidence packet and understood that his job was not to win, but to manage the damage. At 9:05, the commission chair, a retired appellate judge named Marion Cross, 71 years old, silver-haired, with a voice that carried the particular authority of someone who had spent 40 years issuing rulings that could not be ignored, called the hearing to order. This is a formal hearing of the Virginia Judicial Inquiry and Review Commission, convened pursuant to Virginia Code Section 17.1-902 in the matter of complaints against the Honorable Lowell R. Meade, Judge of the Henrico County Circuit Court. Case number JIRC Gotch, Noi Hai Ngin Kong Trum Hai Mui Lum Gut Noi, Hom Kong Ba Mui Chin. She paused. Let the case number settle into the room. The commission will hear testimony and receive evidence regarding allegations of judicial misconduct, including but not limited to racial bias in courtroom proceedings, denial of due process, improper sanctions, and failure to maintain the standards of conduct required by the Virginia Code of Judicial Conduct. Meade sat very still. His hands were on this table, fingers interlaced, the posture of a man who had been told by his attorney to project composure and was doing so with the rigid effort of someone holding a door shut against wind. The commission calls senior investigator Angela Mercer. The side door opened. Angela entered the hearing room. She was not wearing the worn blazer, not carrying the battered satchel. She wore a charcoal suit, fitted, professional, the kind of suit that said government official, the way Meade's robes said judge. Her JIRC identification badge hung from a lanyard around her neck, its gold seal catching the overhead lights. She carried a leather portfolio, new, unbattered, and walked to the witness stand with the posture of a woman who had been in rooms like this before and understood exactly what they required. Meade saw her. Recognition took 3 seconds. The first second, confusion. The face was familiar but out of context, like seeing a neighbor in a foreign airport. The second second, placement. The blazer, the satchel, the podium in courtroom 3. the pen moving across a legal pad. The third second, understanding, and with understanding, a physical reaction that began in his chest and radiated outward. His hands separated. His fingers gripped the edge of the table. The color that had been receding from his face since he opened the commission's envelope 6 weeks ago now completed its withdrawal, leaving his skin the gray-white of old newspaper. His lips parted. No sound came out. His left hand moved to his chest, the same gesture a person makes when checking for a heartbeat they are no longer sure is there. Harold Crenna placed a hand on Meade's forearm. The touch was professional but firm, a physical anchor. Stay seated. Stay quiet. Whatever is happening, do not speak. One of the reporters in the gallery, a woman from the Richmond Times-Dispatch, leaned forward in her seat and wrote something in her notebook with the rapid intensity of a person who has just realized the story she came for is not the story she is getting. The story she is getting is bigger. Meade's mouth opened, closed, opened again. He was looking at Angela the way a man looks at a document that changes everything he thought he knew. Not with anger, not yet, but with the disorienting vertigo of a person who has just discovered that the floor he has been standing on is not solid. That the woman he spent 3 weeks humiliating, sanctioning, and ordering removed from his courtroom was not a pro se litigant who didn't know the law. She was the law. She had been the law the entire time. And every word he had said to her, every "people like you," every "go to law school," every "I said so," had been recorded, time-stamped, authenticated, and was now sitting in a portfolio on the witness stand of a hearing room where he was the subject. The irony was not lost on anyone in the room. The man who had spent 22 years sitting above other people, passing judgment on their words and their behavior and their worthiness, was now seated below the witness stand, looking up at a woman he had once looked down upon, listening to his own words being played back to him in a proceeding he could not control. Angela took the oath. She sat in the witness chair. She opened her portfolio. Please state your name and title for the record. Angela Mercer, Senior Investigator, Virginia Judicial Inquiry and Review Commission. Assigned to case number JIRC Gotch Noi, Haingin Kong Trum Haimui Lum Gat Noi. Hong Kong Bamui Chin since February 12, 2025. The gallery stirred. The reporter's pens moved. At the respondent's table, Meade's breathing had become audible, shallow, rapid, the respiratory pattern of a man whose body was processing information faster than his mind could organize it. Investigator Mercer, please describe the scope and methodology of your investigation. Angela's voice was level, unhurried, the same voice she had used in courtroom 3, neutral as a glass of water, but now carrying a weight it had not carried before, the weight of authority, of title, of the entire apparatus of the Virginia Judicial Inquiry and Review Commission standing behind every word she spoke. Beginning February 12th, I conducted an undercover assessment of courtroom conduct in the Henrico County Circuit Court, Courtroom 3, presiding Judge Lowell R. Meade. The investigation was initiated following the Commission's receipt of 47 formal complaints spanning 14 years, alleging racial bias, procedural violations, and denial of due process. I entered the courtroom as a pro se litigant in a civil housing matter. Case number CL Gotch Noi, Hai Ngin Kong Trum Haimui Lum Gat Noi, Hong Bon Bon Mot 7, in order to observe and document judicial conduct from the perspective of an unrepresented party. Crenna stood. He had to. This was the moment to object or lose the chance. Madam Chair, the respondent objects to the admissibility of evidence gathered through what amounts to a sting operation. Investigator Mercer fabricated a legal dispute to gain courtroom access under false pretenses. This methodology raises serious due process concerns and potentially taints the entire evidentiary record. Angela did not wait for the chair to respond. She addressed the objection directly, not to Crenna, but to the Commission. The housing petition was filed in compliance with Virginia law. No false identity was used. No false documents were presented. The JIRC's statutory authority under Virginia Code Section 17.1-902 permits investigation of judicial conduct through any lawful means. Filing a civil case is a lawful act available to any citizen. The investigation was authorized by this Commission on February 12, 2025, by unanimous vote. The chair looked at Krenna. The objection is noted for the record. The commission will evaluate the methodology as part of its deliberation. The evidence is admitted pending that evaluation. Please continue, Investigator Mercer. Angela opened her portfolio to the first tabbed section. Exhibit A, audio recordings. She pressed play on a small device connected to the hearing room's speaker system. The room filled with sound. The ambient noise of a courtroom, the shuffle of papers, the hum of fluorescent lights. Then a voice. Meade's voice. Clear, contemptuous, preserved in digital clarity. People like you always think you understand the law. The recording paused. Angela spoke into the silence. Exhibit A, Recording 1, March 3, 2025, KCL Gatnoi 2025 Gatnoi 04417. Timestamp, 9:47 a.m. The respondent directed this statement to the petitioner, myself, operating in my investigative capacity, during an initial hearing on a civil housing matter. She pressed play again. A different recording, same courtroom, same voice. The legal basis is that I said so. This is my courtroom. If you want to play lawyer, go to law school. Exhibit A, Recording 3, same date. Timestamp, 9:52 a.m. The respondent denied my request for a legal basis for limiting my witness list, then directed me to go to law school. Another recording. Do not lecture me on due process in my courtroom. Exhibit A, Recording 7, March 19, 2025, timestamp 10:11 a.m. 11s. The respondent interrupted my attempt to respond to a sanctions motion and raised his voice in a manner audible to the entire courtroom. She let the recordings breathe. Let the room sit with the sound of a judge's voice stripped of the visual authority of robes and bench and elevated seating. Just words, floating in a wood-paneled room, sounding exactly like what they were. A man speaking to another human being with the contempt of someone who believed consequences did not apply to him. Exhibit A contains 12 recordings across 4 hearing dates. Each recording is indexed by date, timestamp, and content summary. All files were downloaded from my recording device to the JIRC secure server on March 27, 2025, by digital forensics specialist Raymond Hess. File integrity was verified via SHA High-Trum Num Muisao hash. Chain of custody is documented in Exhibit A, Sub-Exhibit 12. She turned to the next tab. Exhibit B, Transcript Comparison. She produced 2 documents, the official transcript and her comparison chart, and placed them on the display screen. This exhibit compares the official transcripts of 2 hearings, March 3rd and March 19th, as certified by court reporter Nolan Voss, against the audio recording submitted as Exhibit A. She pointed to the first highlighted entry. Official transcript, page 14, line 7. The court addressed the petitioner regarding procedure. Audio recording, same timestamp. People like you always think you understand the law. She moved to the second entry. Official transcript, page 7, line 14, March 19th. Hearing. The court reminded the petitioner of proper courtroom decorum. Audio recording, same timestamp. Do not lecture me on due process in my courtroom. Third entry. Official transcript, page 9, line 21. The court advised the petitioner regarding the complexities of self-representation. Audio recording. People who come into my courtroom thinking they know the law, without training, without credentials, without any understanding of how this system works, they tend to leave with less than they came in with. The room was silent. The reporters had stopped writing and were simply listening. One of the commissioners, a woman in her 60s, the law professor, had removed her reading glasses and set them on the table, the unconscious gesture of a person who no longer needed to see the page because the words were hitting somewhere deeper than the eyes. Exhibit B documents 18 discrepancies across 2 hearing transcripts. 3 involve complete omissions of judicial statements. 8 involve material alterations that change the tone and substance of recorded remarks. 7 involve minor modifications, word substitutions that soften language. Court reporter Nolan Voss certified both transcripts as accurate under oath. His signatures appear on the final pages of each. Exhibit B, Sub-Exhibits 1 and 2. Krenna did not stand. He made a note on his legal pad. He had reviewed the transcript comparison in his preparation materials and had already advised Meade that this exhibit was, in Crenna's private assessment, indefensible. His strategy now was containment, limit the hearing's scope, challenge the methodology, and negotiate the outcome. He was not trying to prove Meade innocent. He was trying to keep Meade employed. Angela continued. Exhibit C, Complaint History. She placed a spreadsheet on the display screen. 47 rows, each representing a formal complaint filed against Judge Meade between Hai Ngin Kongtrum Muimot and Hai Ngin Kongtrum Hai Muilum. This exhibit catalogs 47 complaints received by the JIRC from citizens alleging misconduct by the respondent. 31 allege racial bias. 14 allege procedural violations. 2 allege both. All 47 were initially processed through the Henrico County Circuit Court's internal complaint procedure, a process administered by Clerk of Court Piper Stokes. She paused. All 47 were dismissed. Average processing time from receipt to dismissal, 71 hours. No complaint reached the investigative stage. No complaint resulted in notification to the respondent. No complaint was forwarded to this commission through the standard referral process. A commissioner, one of the retired judges, a man named Wallace Odom, who had spent 30 years on the Virginia Court of Appeals, leaned forward. Investigator Mercer, are you saying that 47 complaints against this judge were processed and dismissed by a single clerk without any referral to external oversight? That is what the records indicate, Commissioner Odom. The JIRC received these complaints through alternative channels, direct citizen submissions, forwarded copies from legal aid organizations, and a batch referral from the ACLU of Virginia in 2023. The Henrico County Clerk's Office did not forward any of them. Is there a written policy governing the clerk's role in complaint processing? There is. Henrico County Administrative Order 2008-14 establishes that complaints against judicial officers must be forwarded to the JIRC within 10 business days of receipt. Clerk Stokes acknowledged this policy in a 2022 email to the court administrator, Exhibit C, Sub-Exhibit 9, in which she stated, and I quote from the email dated April 12, 2022, subject line, Complaint Procedures Update. All judicial complaints are processed per A, O 2008-14. End quote. She let the contradiction sit in the room. 47 complaints. A written policy requiring forwarding. An email confirming compliance with that policy. 0 referrals. Exhibit D, Use of Force. This was the exhibit Angela had been dreading, not because the evidence was weak. It was not. But because the evidence was her body. Her bruises, her pain, documented in clinical language by a physician who had no context for what she was seeing, beyond patient reports injuries sustained during physical contact by courthouse security personnel. On March 19, 2025, Deputy Bailiff Gage Lindell physically escorted me from Courtroom 3 on the respondent's order. The escort involved a grip on my left upper arm that resulted in contusion documented by Dr. Karen Liu at MedExpress Urgent Care, Richmond on the same date. Clinical photographs are included as Exhibit D, Sub-Exhibit 1. She displayed the photographs. Her arm, the bruising, dark purple against brown skin, the outline of 4 fingers visible in the pattern of discoloration. On March 26, 2025, Deputy Bailiff Lindell and 2 additional deputies physically removed me from the courthouse following the sanctions hearing. The removal involved a grip on my left upper arm, the same location as the previous injury, a wrist control hold on my right wrist, and a push on the staircase landing that caused me to stumble. Medical documentation from the same facility, same physician, Exhibit D, Sub-Exhibits 2 through 4. She displayed the second set of photographs. The layered bruising on her arm, fresh purple over healing yellow, a palimpsest of institutional violence. The wrist, with its thumbprint bruise, already photographed from 3 angles. Both incidents were captured by the recording devices I carried as part of my investigative equipment. Audio files are cross-referenced in Exhibit A. Commissioner Odom spoke again. His voice was quiet, but it carried. Investigator Mercer, Were these injuries reported to the Henrico County Sheriff's Office? No, Commissioner. Filing a report with the Sheriff's Office would have required identifying myself and revealing the investigation. The decision to delay reporting was made in consultation with my supervisor, Digital Forensics Specialist Hess, in accordance with JIRC operational protocols for undercover assessments. Odom nodded. He looked at Meade. Meade did not look back. He was staring at the table, at his own interlaced fingers, at the surface where his hands rested with the stillness of a man who had discovered that the table was the only thing in the room that would not judge him. Angela closed her portfolio. Exhibit E documents the chain of custody for all evidence submitted. Exhibit F contains supplementary materials, courthouse security logs obtained via FOIA, filing receipts with timestamps, and 114 index cards documenting daily interactions throughout the investigation period. She took a breath, the first one she had allowed herself since sitting down. I have one final statement for the commission. The chair nodded. Angela looked at Meade. Not with anger, not with triumph. With the level, unhurried gaze of a woman who had spent 3 weeks being told she didn't understand the law by a man who had never suspected she understood it better than he did. I didn't need authority in that courtroom. I needed accuracy. Judge Meade spoke freely because he believed no one with consequence was listening. He interrupted me because he assumed I had no recourse. He sanctioned me because he believed the process would protect him, the way it had protected him for 22 years. She paused. 47 people filed complaints before me. 47 people stood where I stood, heard what I heard, and tried to tell someone. None of them had the resources I had. The recording devices, the institutional backing, the training. They had only their words, and their words were dismissed 71 hours after they were filed by a clerk who reported to the judge they were complaining about. Another pause. The room was very quiet. The question before this commission isn't whether Judge Meade said these things. The recordings confirm that he did. The question is why 47 complaints weren't enough to bring us to this room sooner. She closed her portfolio. She sat back. She was finished. Harold Crenna presented the respondent's case for 90 minutes. He challenged the investigation's methodology. He argued that undercover operations in courtrooms set a dangerous precedent for judicial independence. He presented character witnesses, 2 attorneys who testified to Meade's rigorous but fair courtroom management. He argued that the transcript discrepancies were the responsibility of the court reporter, not the judge, and that Meade had no knowledge of alterations. The commission listened. They asked questions. They took notes. They did not appear persuaded by the character witnesses, one of whom, under questioning from Commissioner Odom, admitted that he had never appeared before Meade as an opposing counsel, only as co-counsel with Wynne Calloway. The other acknowledged that his experience was limited to commercial cases and that he had no basis for comparison regarding Meade's treatment of pro se litigants. At 12:45, the chair adjourned the hearing for deliberation. The commission would issue its findings within 30 days. The findings arrived on July 17th. They arrived in stages, the way institutional accountability always does. Not as a single moment of justice, but as a series of incremental actions, each one limited in scope, each one contested, each one producing a result that was simultaneously too much for the people who benefited from the status quo, and not enough for the people who had suffered under it. The JIRC issued a formal censure of Judge Lowell Meade for violations of the Virginia Code of Judicial Conduct, Canons 1, 2, and 3, failure to uphold the integrity of the judiciary, failure to perform duties impartially, and failure to conduct proceedings in a manner that treats every person with respect. The censure was accompanied by a recommendation to the Virginia Supreme Court for suspension from the bench. The Supreme Court acted on August 4th. Meade was suspended with pay pending a full disciplinary hearing, scheduled for December. Not removed, not terminated. Suspended with pay, the institutional equivalent of a parking brake, slowing the vehicle without stopping it. Meade's attorney filed an appeal the same afternoon. The Virginia State Bar opened an ethics investigation into Wynne Calloway on July 22nd. The investigation focused on 3 areas: filing a frivolous sanctions motion, omitting the court-ordered removal from a default judgment motion, and a pattern of appearing as counsel in cases where judicial rulings consistently and disproportionately favored his clients before Judge Meade. Callaway retained his license pending review. He issued a statement through his attorney describing the investigation as politically motivated and expressing full confidence in the disciplinary process. He continued practicing law. He continued appearing in Henrico County courtrooms, though not in Courtroom 3, which was now dark. The Attorney General's office opened a criminal investigation into Nolan Voss on July 25th. The investigation centered on 18 documented instances of transcript falsification across 2 hearing dates, with the strong implication, flagged in the JIRC's referral, that the pattern extended far beyond Angela Mercer's case. Voss was placed on administrative leave. His attorney argued that transcript discrepancies were routine summarization and did not constitute falsification. The AG's office disagreed. A grand jury was convened in September. The outcome remained pending. The Henrico County Sheriff's Office initiated an internal affairs review of Deputy Bailiff Gage Lindell on August 1st. The review examined 2 documented use-of-force incidents involving Angela Mercer and cross-referenced them with Lindell's personnel file, which contained, the review committee discovered, 3 prior complaints of excessive force from courthouse visitors over the previous 4 years. All 3 had been resolved through informal counseling with no formal documentation. Lindell was transferred to administrative duties in the county records office, not suspended, not terminated, transferred, moved from one desk to another, his badge and authority intact, his pension undisturbed. The courthouse security union filed a grievance on his behalf, arguing that the transfer constituted punitive reassignment without due process. The grievance was pending. The Henrico County Board of Supervisors held an emergency closed session on July 29th. The session lasted 4 hours. 3 members argued for immediate suspension of Piper Stokes. 2 argued that personnel actions should wait for the outside review. The county attorney, mindful of the union contract, the grievance process, and the political cost of appearing to act without due process, even when due process had been denied to 47 complainants, recommended caution. The board sided with caution. It was the safe choice. It was the choice that institutions always made when the cost of action exceeded the cost of inaction, measured not in justice but in liability. Afterward, the board issued a press release announcing a comprehensive review of complaint processing procedures in all county court facilities. The review would be conducted by an outside consultant, not yet selected, with findings expected within 6 to 9 months. No interim changes to complaint processing were announced. No personnel actions were taken regarding Clerk Piper Stokes, who continued to operate the clerk's window with the same brass nameplate and the same sliding glass and the same theatrical slowness she had applied to Angela Mercer's filings. Angela read the board's press release on her laptop and felt the particular exhaustion of a person who has seen this exact outcome before, in other courthouses, in other counties, in other states. The announcement of a review that would produce a report that would recommend changes that would be implemented partially, monitored briefly, and forgotten completely within 18 months. She had watched this cycle in 9 states over 11 years. She knew its rhythms the way a farmer knows the rhythms of a season that always arrives late and leaves early. The Department of Justice Civil Rights Division sent a letter to the Henrico County Board of Supervisors on August 12th. The letter requested records and documentation related to complaint processing, transcript accuracy, and courthouse security practices. The bureaucratic language of a preliminary inquiry, the step before a formal investigation, the knock on the door before the door is opened. Whether the preliminary inquiry would become a pattern or practice investigation under Bon Muy Hai, USC section. Muy Bon Ngin Mot Trum Bon Muy Mot depended on what the records showed. The county's attorneys were already preparing their response. The word consent decree had not yet been spoken aloud, but it hovered at the edges of every conversation in the county administrator's office, like a sound just below the threshold of hearing. 6 layers of consequence, 6 institutions responding, 6 timelines running in parallel, each one moving at its own speed, each one producing results that were simultaneously meaningful and incomplete. Meade suspended, but not removed. Voss under investigation, but not yet charged. Calloway under review, but still practicing. Lindell transferred, but still employed. The Board of Supervisors studying the problem. The DOJ asking questions. It was not justice, not yet, not fully. It was the machinery of accountability beginning to turn, slowly, with the grinding reluctance of gears that had rusted in place over 22 years of disuse. Angela Mercer learned about the outcomes in stages, through official channels, phone calls from Raymond Hess, emails from the Commission's staff attorney, a formal letter acknowledging the completion of her investigative assignment. She read each notification in her apartment in Norfolk at the kitchen table, with Verdict the cat sleeping on the chair beside her and the television off and the apartment quiet, in the way that apartments are quiet when they contain only one person and the weight of what that person has experienced. She did not celebrate. There was nothing to celebrate. Not yet, and perhaps not ever, because the system she had investigated was not a person who could be punished and reformed, but a structure that had been built, maintained, and protected by hundreds of decisions over decades, and dismantling it would require more than one investigation, one hearing, one censure. But on August 9th, her phone rang. The caller ID showed a Virginia number she didn't recognize. She answered. "Investigator Mercer?" A woman's voice, young, nervous, familiar, in a way Angela couldn't immediately place. "This is Dara Wells, from the Henrico County Clerk's office." Angela set down her tea. "I know who you are, Dara. I needed to tell you something. I've been working in that office for 3 years. I filed 2 of those 47 complaints myself. One in 2023, one in 2024, both about Judge Meade, both about how he treated people in his courtroom." A pause. Angela could hear the woman breathing, the careful, controlled breath of someone speaking words she had practiced. "Nothing happened. Both times Piper told me the complaints had been forwarded. Both times I checked the system and they weren't there. I asked her about it. She told me to focus on my job. She said complaints were handled at the administrative level, and that clerks didn't need to concern themselves with the process." "Dara, I sent you that text, the photograph of the 2014 complaint. I found it in a storage box in the basement. Complaint forms that were supposed to have been forwarded and weren't. The boxes were labeled Archive, Destroy after 7 years. But they hadn't been destroyed. They were just down there in the dark, with the water heaters and the old filing cabinets. 35 more complaints. 35 people who wrote letters and thought someone would read them." Angela's hand tightened around the phone. 35. The exact number missing from the JIRC's file. The ones Piper Stokes had claimed were routinely purged per office policy. The policy that produced no written documentation when investigators asked for it. Not purged. Boxed. Buried in a basement beneath a courthouse that processed complaints the way it processed everything else, quickly, quietly, and with the understanding that certain voices were not meant to be heard. "I was scared." Dara's voice cracked, the sound of composure giving way to something raw. "I watched them search your bag. I watched Lindell grab your arm in the hallway, and I was standing 20 feet away, and I didn't move. I didn't say anything. I watched Piper close her window while you stood there asking for a filed copy, and I pretended I was busy with paperwork. I watched everyone in that building treat you like you were nothing, and I—" She stopped. A breath. 2. "I couldn't do anything except send you that photograph and hope it mattered." Angela closed her eyes. She thought of Dara Wells in the hallway 3 weeks ago, saying Ms. Mercer with a formality that didn't match a clerk greeting a pro se litigant. The first crack in the courthouse's wall of indifference, so small that only Angela and Piper Stokes had noticed it. She thought of the anonymous text on the night of March High Musau, arriving in the dark hours after Lindell's hands had left bruises on her arms and Meade's gavel had dismissed her case. She thought of the word written beneath the clerk's stamp. More. And what it must have cost a young woman earning a courthouse salary, with no protection, no badge, no investigation behind her, to type that word and press send. It mattered, Dara, more than you know. What happens now? Angela looked at the cat, at the kitchen table, at the apartment that was quiet and safe and 7 miles from the nearest courtroom. Now the process continues. The commission has the findings. The AG has the transcript evidence. The DOJ is asking questions. It's slow. It might not feel like enough. It feels like a start. It is a start. They hung up. Angela sat at the table for a long time. The tea cooled. Verdict stretched, yawned, resettled on the chair with the boneless ease of a creature that had never been required to document its own mistreatment in order to be believed. A start, not a victory, not justice, a start. 3 days later, an envelope arrived at Angela's Norfolk address. No return address. Standard white business envelope, the kind available at any office supply store. Postmarked Richmond, Virginia. Inside, a single sheet of paper. A photocopy of a Henrico County Courthouse complaint form, dated 2014. The complaint alleged that Judge Meade had dismissed a custody case, Williams versus Williams, without hearing testimony from the mother, a black woman named Carla Williams, and awarded sole custody to the father. The father's attorney of record was Wynn Calloway. Angela recognized the case, not from the investigation, from the courtroom. Carla Williams, the woman whose continuance had been denied in 4 minutes and 11 seconds while Angela watched from the gallery. The woman whose 10-year-old daughter had looked back at the judge's bench with an expression that was not childlike at all. The complaint form bore the familiar clerk's stamp, received, clerk's office. Beneath it, in the same handwriting as the first photograph, Dara's handwriting, Angela now recognized. 2 words this time, not done. Angela set the paper on her kitchen table. She looked at it for a long time. Then she opened the drawer where she kept her index cards. A fresh stack, purchased at the Norfolk Staples, identical to the ones she had carried in the satchel, and pulled one out. She wrote the date. She wrote the source. She wrote the case name, and the year, and the allegation, and the name of the opposing counsel who appeared in both this case and her own. She did not write a conclusion. Conclusions were for reports, for hearings, for proceedings with formal docket numbers and 7 commissioners behind a long table. What she wrote on the index card was a beginning. A new card for a new stack, the first entry in a chronology that would grow the way all her chronologies grew. One careful notation at a time, building toward a reckoning that no one could see yet, but that was coming, the way weather comes, the way consequences come, the way truth comes when someone is patient enough and accurate enough to write it down. She slid the card into the pocket of her satchel. The old one, the battered one, the one with the scuffs and the water stains, and the lining that still held the outline of a recording device. Outside, the Norfolk evening was warm and still. Somewhere in Henrico County, a courthouse stood on East Parham Road with its lights off and its courtrooms dark, a building that had operated for decades on the assumption that power was what happened in a room, and that what happened in a room stayed in that room. Somewhere in that building, a clerk's office held boxes of complaint forms that had never been forwarded, testimony that had never been recorded accurately, and the bureaucratic evidence of a system that had learned to process its own failures with the same efficiency it processed everything else, quickly, quietly, and without leaving a trace. But traces had been left. In audio files on a secure server, in medical records at an urgent care clinic, in index cards written in small, even handwriting by a woman who had been told she didn't understand the law, in photographs of bruises that had faded from skin but not from evidence files, in the voices of 47 people who had written letters that went nowhere until someone came along who knew how to make them go somewhere. The investigation was not over. The hearing was not the end. The start was not the finish. Angela Mercer knew this. She had always known it. Justice was not a destination. It was a direction, slow, imperfect, purchased with bruises and index cards and hours of typing in hotel rooms at 3 a.m. It did not reward speed. It rewarded accuracy. It rewarded the willingness to sit in a room where you are being humiliated and write down every word. She had written them down, everyone, and somewhere in a drawer in the Henrico County Clerk's office, in a box that Dara Wells had found in a basement that smelled of mildew and institutional neglect. 35 complaint forms waited in the dark, each one a voice, each one a story, each one a person who had stood before a man in a black robe and been told that people like them didn't understand the law. They understood it now, or rather, the law was beginning to understand them, but that process was just starting. And the road between a start and a finish, between a complaint form in a basement and a judge removed from a bench, was long and winding, and paved with the kind of patience that most people could not sustain, and that Angela Mercer had built her entire career around. She closed the satchel. She finished her tea. She turned off the kitchen light. Tomorrow, there would be more work. There was always more work.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.